And I guess I'm assuming that even if that were denied, you'd want a hearing on that as well.
Of course.
Okay. So maybe we can schedule that for the same time on the 28th, was it on the 30th,
30th
of April?
That's why I brought it up now, because that might be the easiest way to address that, have a showdown on the
Okay.
30th.
All right. So hopefully it won't be a showdown. I'm hoping that you actually can come to some resolution, but.
That would be fine too.
Any issues with that, maybe scheduling. I do have a regular protective order calendar. I've been trying to keep this matter off of that so that I didn't have issues with trying to manage those other matters that might be difficult to manage if this case is also on the regular protective order calendar.
Your Honor,
We're going to be here anyway.
Yeah, I'll leave it to the discretion of the court. The only thing at this point, that we really just want to make sure that, and I mean, this would have had to have been disclosed in the other protective order, that this case is existing for the purposes of, custody orders, and that being combined to one case so that, we just have one case looking at custody.
It'll still be two cases. I think since it's the same incident, I typically, when I have competing protective order requests, I'll just call them both at the same time. All right?
That would be fine, Your Honor.
And this case was disclosed in the new one, just to address counsel's concerns.
Right, and they're very careful, and Commissioner Olson is very careful not to issue competing custody orders that might lead to chaos reigning. We don't want that to happen either. All right, I do have one question too before we begin, going back to the initial petition. And when I looked at the allegations, the way it was described, Dakota was pro se, I believe, when he filed this. I don't think he listed having an attorney at that time. But it said he listed the most recent incident as February 23rd and February 24th of 2025. I'm thinking that was a typo. And
That has to be a typo,
because that
yes.
changes the analysis a little
Yes.
bit. Okay.
Yes, Your Honor, that was a typo. The most recent incident would have been February 23rd and 24th of 2026.
Okay. Any other preliminary matters before we get into the merits on parent time?
Not that I'm aware of.
Okay.
Your Honor, the videos that were submitted by Petitioner, were you able to watch those?
I did. Yeah. Okay. All right. Very good then. Then I believe, Mr. I should say, Ms. Diaz, you're the petitioner's counsel on this, so I think you'd be up first.
Yes, Your Honor. So as you already outlined today, we're just trying to look at what types of custody modifications can be made to this order before we all meet again on the 30th.
Okay.
Given the evidence that's been submitted in this case, the allegations in the petition, we would like to see visitation be supervised, and we'd like to see it preferably by a facility.
Mm-hmm.
That can act as a go-between between the parties. We do not believe that it would be safe for my client, for the parties to communicate directly with each other about this. It's also my understanding there aren't really any other options at this point either. And based on the evidence that has been submitted here, I think it's appropriate for safety, given that this is a DV case.
Can I ask one question about this? I even before it was filed with the court, I'd been reviewing. I'm also assigned to the domestic matter. So I did notice that even after the allegations that led to the criminal charges in 2023, they had come to a resolution. They settled their custody case. And I'm gathering this kind of maybe blows that up to a degree, but how do you...
So my understanding with the
reconcile
custody case is that a resolution was reached and a stipulation was signed.
Never
but
entered.
It was never entered. There still haven't been financial documents submitted, I believe, by the respondent on that case. Mrs. Paul, it hasn't submitted them, and so that's why it hasn't been entered. And so, I think that the very nature of a protective order is right, like, these things could still be negotiated and dealt with in the custody case, and another agreement could be reached. It hasn't technically been entered, but even if it had, it could have been modified. So
let me ask this too: is he alleging that she's ever done anything that was aimed at the children, directly at the children, or it was incidental, her actions towards him, that where the children happened to be present, or one or more child happened to be present?
Your Honor, we're alleging both, that in the moments where the respondent is out of control, and in these moments where the parties are fighting and she is completely out of control, both things happen. She is completely reckless in her behavior towards the children. So yes, if they happen to be in the line of fire when she's coming at him, yes, they will get harmed. I'll draw the court's attention actually to our Exhibit 8, in which my client was holding, their young child.
Well, my question is really more where the anger was directed.
And we believe also that this is a case that, as we look deeper and deeper into the evidence, that you'll see that there's a lot of sort of coercive control happening, and that does involve sometimes, like acting violently around or towards or slamming the doors of the child's room, trying to disrupt and involve the child in the violence in order to get my client to react.
Okay. All right. Let's hear the response, and then I'll go to the guardian ad litem. We'll work our way back to the petitioner.
Great. So you want us to go now, Your Honor?
Please.
Can I approach?
You can. Anything you're handing me that hasn't already been provided? It's already been provided to counsel?
Yeah, exactly. Filed with the court, counsel has courtesy copies of it, so maybe you need that,
Probably
maybe you
reviewed it
don't.
already. Okay.
Wanted to draw the court's attention to a few different aspects of this case. We're requesting today that the parties return to the status quo as outlined in their August 2025 settlement agreement in the custody action. There is a little bit of procedural back of Mr. Mortensen. I understand that today's not the, you bristled when I used the word showdown, so I'm not going to use that again. I know that today's not the final protective order hearing that's tentatively set for the 30th, but we do have to, I think, dip our toes into the water a little bit to understand the dynamics here between these parties. Then I'll end my argument by looking at the statute, because I just don't know that it automatically triggers supervised parent time for my client in this particular case. The provisions of the temporary protective order that give us heartburn, to put it mildly, would be paragraphs 15 through 17. This is a total suspension of my client's interactions, contact with their 2-year-old son.
Now, I'll add that ex parte order is exactly that. It was made without your client having been given yet the opportunity to be heard. Yeah.
My point in bringing this up, it's obviously not unheard of. We see this in certain cases, and in certain cases it is appropriate. Makes no sense here, and I think it speaks to how vindictive Mr. Mortensen is.
He's not asking for today, at least for suspension of parent time, right? He's asking for supervision.
We
That's
learned that.
correct.
We learned that today. You're correct.
Okay.
Also important to note in this case, Your Honor, that he has not actually asked for supervision in his pleadings, but I'll come back to that in a moment. These parties, very small background here, Your Honor, these parties' relationship began in, I believe, 2022, could have been 2023. The child, their 2-year-old son, was born March 19th, 2024, which maybe this is a coincidence, maybe it's not, but March 19th is the same day that Mr. Mortensen chose to file his protective order against our client. I'll say something very uncontroversial, and that is that these folks have had a tumultuous relationship, lots of fighting. This course over the course of today's hearing, as well as the next few weeks, we'll see that both sides have a lot of allegations against the other that are going to be lobbed against the other in this case and in the new protective order filing. Mr. Mortensen, as the court pointed out, filed a custody action on June 25th of last year, and that case was settled August 22nd of last year. I think those dates are pretty important because, as the court already indicated, 8 of the 11 exhibits submitted by Mr. Mortensen predate his settlement agreement, which again I think calls into question, not absolutely, but I think it would call into question the relevance of these exhibits for purposes of custody and supervision.
Where I think it comes into play is that the statute specifically states that the passage of time per se, cannot be the only basis for denying the request for a protective order. Certainly, I consider whether there may be ulterior motives, like trying to gain a leg up in a custody dispute, right?
Right.
Yeah.
Nope, I'm with you, Your Honor. Importantly, in the custody case, he didn't ask for supervision there at any stage that I'm aware of. And like I mentioned, they
That was
said,
before the February incident.
yeah, but also after 8 of the 11 incidents. And,
All right.
you know, I'm excited to talk about February because I think that is critically important to look at today. So
Okay.
we'll get there in just a moment. This was settled August 22nd. Both had lawyers. Mr. Mortensen was represented by Mr. Hansen. Taylor was represented by our office with Mr. Ficklin running point on the case. And the result of that settlement is Taylor has custody of this child. It's roughly a 70-30 division. It's
I read it.
mathematically.
It was 20 of 28 days over a 4-week schedule for her overnights.
Yep, there you go. You've read it. You've done your homework. Appreciate that. So that, again, I think that this procedural backstory does call into question the necessity of supervision at this stage. Also, transitioning in my argument at this point.
Before you go there, let me just ask. We don't have video, do we, of the February incident at all, right?
one's
Everything
given
that
me
I've
video.
seen is the aftermath.
Right.
People talking to each other, recorded text messages that happened after the fact. For this February incident, I don't think there's any video evidence. So at least I haven't seen it yet.
That's my understanding, and I don't believe Mr. Mortensen has provided anything related to February.
Okay. all
Either
right,
party.
All right.
And that's
And
your
what is
second
the
question about
status of the
February, so I'm
police
skipping ahead to February,
Okay.
because I think that that is obviously important for the case, and I can come back to a couple things
All right.
that I also think are important for the court. As for February, this is a perfect data point in this case to evaluate Mr. Mortensen's credibility, or the lack of credibility, as is the case here. And I understand Mr. McDonald will want to talk about 2023. Mr. Mortensen will, of course, want to talk about the 2023 incident, the well-publicized 2023 incident. Mr. Mortensen has already raised the 2025 incident. I get that, and we can have a separate discussion about each of those. I want something very recent, very fresh for this court to evaluate in terms of looking at the party's conduct. And February, we are one day off, by the way. So Mr. Mortensen, in his request for a protective order, alleged that these events took place on the 23rd and 24th.
Is it material?
No, but I'm just clarifying because each party may reference different dates but the same events, so I wanted you to understand.
Okay,
The
all right.
events, as my client understands it, took place the very early morning hours, about 6 a.m. or so, of Sunday, February 22nd, and then the following day after midnight on the 23rd. So 2 separate incidents, 2 separate interactions, and I'm looking at, for purposes of today, I'm looking at the 23rd, or what I call the truck tussle. Essentially, both parties allege that they were having, that Dakota came over to Taylor's house to.
I think was most of the incidents, right? Where she lived? I'm trying to go through that, but that's okay. You keep going. Keep going.
Yeah. So essentially, they've had obviously a tumultuous relationship, and there's been a very well documented history of Dakota trying to re-engage and re-enter and resume the relationship. And one such example took place on February 23rd of this year, early morning hours, soon after midnight.
Before the violent episode, right? Before the incident.
Yeah.
Yeah.
This is that incident, the truck tussle. So kids are sleeping inside, the 3 children that my client has, 2 with her ex-husband and 1 with Mr. Mortensen. They're sleeping inside her home in Draper. Mr. Mortensen comes over, and my client decides, fine,
Why did he come over?
talk about the relationship.
Not to pick up the kids? It wasn't
No,
his turn?
no,
to
middle
have
of the
kid
night. It wasn't related to
Invited
the
over,
children.
or did he just show up with unannounced?
I think it was by invitation. In other words, she acquiesced to his coming over.
Okay, all right.
Kids are sleeping. She doesn't want it to escalate and turn into an argument, so she says, fine, I'll talk, but let's do it in your truck. So they go in and they sit in the front seat of the truck, and things immediately start to escalate. He drives away with her in the truck against her objection, and then something happens. Okay? I say something because this is where there's a huge divergence in the stories. You've read the request for protective orders supplied by Mr. Mortensen. He says, Taylor went crazy and she threw a drink and I don't know. She assaulted him, essentially at its core. Taylor alleges that he grabbed her head during the course of this argument and slammed it into the dashboard, and in the ensuing chaos also struck with his fist her knee and her elbow. In that binder in front of you, Your Honor, you'll see exhibits E and F. E shows the progression of a bruise on her forehead that she took.
Kind of yellowish in the picture.
Gets yellow. Yeah. The first one was taken hours after the incident, so not really yellow, but it's discolored. There's a bump. And then the additional pictures within that exhibit show the progression, how the color changes of the bruise. Exhibit F shows something similar. It's a bruise on her knee from when he struck her in the truck. My client would testify
Who
that
took the photos? What's the foundation?
my client took the photos.
On the day of the incident?
The first one was taken, I believe, within hours, so think under 10 hours or so after the incident when the bruise formed.
Were these photos provided to law enforcement?
I don't know what photos were provided to law enforcement, Your Honor.
Right. You don't know whether they took their own photos?
I am not aware of that.
And we don't have a report yet, right, on that
No,
incident.
no. All I've heard from Draper City is that they do not intend to pursue charges against either party. But
Okay.
nothing's really set in stone
Haven't
until.
written a letter to that effect, or
Nope.
Okay.
So all I can tell you is through the grapevine. So not very.
you should get a report in any event, right?
I'm going to spare you my rant about
Okay.
getting police reports.
Well, I know
but yes, I
know
agree.
about the problems with the grammar requests and the delay. I'm referring to there ought to be a report at some point, I would think, right?
Yes, but an unredacted report has not been released.
Okay, all right.
So getting back to this, so both parties essentially at their core, and you'll see in my client's request for a protective order that was filed today, you will eventually see line by line her detail of events that took place in the truck. You've seen in Dakota's request for protective order, it's a bit muddled, but
I haven't read her request.
I understand.
yet.
Not holding you to
I
that.
didn't even know it existed until I came into
Yep.
the courtroom. Okay.
But fundamentally, both parties allege that they were the primary aggressor of a tussle in the truck, and that constitutes assault and a violent act by the other party, and therefore should be part of the basis for a protective order. No one was in that truck but them. What I think is very important is to look at their conduct in the immediate aftermath. I would think, if I'm Dakota in this scenario, what would I do? I would get the heck away from that woman. If we believe his request for a protective order, why would he be in the same room as her? He would need to get as far away from her as he possibly could.
How long have they been separated?
Well, their
They
relationships.
ever lived together?
Sorry, what, Your Honor?
They ever lived together? And if so, when did they separate?
I'm not aware if they ever lived together.
All right, okay.
But they have not been they have not actually maintained a relationship for several months, as my client would define it.
Well, they have a child in common. They have to have continuous interaction with each other in some form.
a traditional
for the remainder of
committed.
the minority of their child.
A traditional committed romantic relationship. They've not been engaged in that for quite some time. So that's what Dakota would have done if he were victimized by Taylor. Get away from this person, right? Now, similarly, if you're Taylor, if you're in her shoes and you're assaulted in his truck, you would demand to be taken home. You'd lock the front door, throw away the key, and you'd say, "Get away from me." That is exactly what she did in the immediate aftermath of the attack. It was Taylor who demanded separation, who demanded that he leave her alone, leave her property, go away. He does not do any of those things. I think, Your Honor, that our Exhibit G is very telling. Exhibit G is a text thread between these parties in the minutes after this supposed attack, the truck tussle. He finally relents, drops her off at her Draper home, but he sticks around. Why does he stick around? Well, we would argue he sticks around because he knew he hurt her and he's trying to manage the chaos that's going to ensue from that. What he does is he lingers on her front doorstep actually, my client would testify, he's physically looking through the window trying to re-engage this conversation.
So is this all about credibility relating to parent time?
It is,
Okay.
because ultimately, everything we're looking at here is, a lot of what we're looking at today relates to his credibility.
I feel like we're getting into the merits of the underlying claim.
And I'm almost off this point. But if we look at Exhibit G, he's telling her, open the door, I'll watch the kids, let me help, open the door. And then he just comes right out and says what he's looking for. This supposed victim of domestic violence is looking for sex, plain and simple. He asks her, do you want to fuck? In the immediate aftermath of her supposedly attacking him. That's what he's looking for. That's what he's physically on her doorstep demanding, as documented by these text messages. So again, Your Honor, I understand we're here with a narrow goal of looking at supervision, but I do think that the court needs to bear in mind the lack of credibility both today as well as at that future hearing. On a couple other arguments related to supervision, Your Honor, it's getting crowded in here in terms of the resources available for these parties.
What do you mean by that?
What I mean by that is there's already a substantial network of friends, family members, therapists, even DCFS caseworkers who are assisting. My client's already meeting with a therapist. We have no knowledge as to whether Dakota is meeting with a therapist, but might be a good idea. As far as DCFS goes, both parties are voluntarily engaged with services with DCFS. We met with our client and DCFS yesterday at our firm's South Jordan office for a transfer meeting.
Is there some kind of services plan that's in place?
Exactly. So a caseworker's been assigned to help both Dakota and Taylor, and those services are about to commence. In fact, there's already scheduled visits with the caseworker to take place later this week.
Let me ask you this, and I'll let you finish. I just wanted to ask, before this February incident, but after the execution of the stipulation in the domestic case, were they acting under the terms of that stipulation in terms of how they were sharing their child?
So from August last year to about February, this is what you're asking. Yes, they did. They implemented that. And I understand one minor point about that, Your Honor. You've already observed that has not been entered in an order, but one of the opening provisions of that settlement agreement is that they agreed to implement this immediately and consider it an enforceable agreement immediately.
Yeah, I anticipate that could be the subject of another motion hearing in the domestic case as to whether or not the court should find that agreement enforceable.
As far as other folks or agencies helping out, there is a guardian ad litem. Both sides have signaled that they'll cooperate. My client has a strong family and support network here in Utah. I'm not aware of Dakota having any. It's my understanding that he's been forced to rely on family members out of state for the last several weeks to watch this child because he doesn't have the network that my client does here. So that's a problem, and I think relevant for supervision purposes. My client simply has the ability to have parent time without overly relying on these third parties. As far as the statute goes, a couple of observations on the statute, Your Honor. Again, supervision was not requested in this case in the both initial request for a protective order and the amended request for a protective order. I understand this court needs to do what's in the best interests of the child.
Was that, then are you saying that was done sua sponte by the signing commissioner?
I actually don't see any mention of supervision in the temporary protective order either. That it's essentially going to be addressed
Suspended.
today.
I mean, we do often, we just, to keep it clean, we'll just suspend. We know we're having a hearing within a couple weeks, and then we'll deal with it.
To clarify what I'm talking about, I'm not talking about the suspension. Dakota did ask for a full suspension of parent time in the request. He did not ask for supervised parent time.
Well, that's more restrictive than supervision, suspension.
I understand. I'm just letting you know that this is something he raised late in the game, so to speak, and we think that there is a prejudicial element to having that entertained today.
Okay.
The statute 819207 provides that this court could enter supervision if there's no less restrictive means available. We do think that there are plenty of less restrictive means available to safeguard this child's interest based on what I just articulated. This is clearly within the court's discretion. The court may order supervised parent time, even when a party pleads it, which Dakota did not. It's within the court's discretion. Additionally, this court would need to enter a supervision order if the court finds that the child will be subject to abuse if left unsupervised.
Well, I guess the one thing I'm concerned about is her volatility, even if he's pushing buttons. Some of the videos suggest that when she finally snaps, there's significance to it. And does that pose a problem for the safety of the children?
Your Honor, you hit it right on the head at the outset of the hearing in asking Ms. Diaz the question of where is the anger directed. Dakota is excellent at escalating and aggravating my client, and when she reacts, it's 100% directed at Dakota. And any exposure the child would have to that.
I'm not saying it's defensible, but you're answering my question, I guess, is what from earlier, right?
Yeah, absolutely. So this is not, my client has she has no risk to these children.
I don't know how you can, that reaction, even where the children are present, in one instance in his arms, I think, right?
You're talking about the May 2025 incident?
Yeah, we're going back, a little ways, yeah.
I want to address this as well as I can for you. What concerns you about that, Your Honor?
Well, I can have concerns about volatility and not reacting in a different way, even if she feels like she's being provoked, when you have a child right there in front of you. And that's my concern there, is that didn't seem to be recognizing that this child was being exposed to that conduct, whereas maybe she could have turned around and walked the other way. I don't know. I wasn't there, of course, but that's one of the concerns that I have from viewing some of the videos.
Yeah, and I'm sure both sides, or at least my client, would prefer to take that one back, right, and redo that one. My comment on May, because I think this will come up, especially when Mr. McDonald speaks, my comment about the May 2025 interaction is it's important to note that's taking place in my client's home, and Dakota started recording only after my client asked multiple times for him to leave. He did not. Even in the video, when the recording starts, she tells him, "Get out of my house, Dakota." What does he do? He does not leave. He plants it right in front of her, and he says, "No, what you're doing is not okay." He's holding the child as his human shield, so to speak, and provoking my client and not getting out of her house. So this idea that...
Well, if that's the case, he got the reaction that he was looking for.
He got the reaction he was looking for.
I'm not making a finding about that, but yeah.
Yeah. The reason I bring this up is Dakota pushes buttons. He's excellent at that. As long as these folks stay apart, which I think is fully stipulated, they need to stay apart. I don't think there's any risk of them coming together again in the aftermath of this. Then there is no risk to the child. No one's going to come into my client's house, whip out their phone and test her, push her buttons and refuse to leave, not to mention the other allegations she's made about full-on domestic violence against her.
Okay.
Finally, Your Honor, so just in conclusion, we would emphasize the child is safe with Taylor. The child thrives with Taylor. We would just ask the court to remember that this is a new request for supervision. It is not in the request for the protective order. There has been enormous passage of time between both the 2023 and 2025 incidents. We just don't think it's appropriate at this point to commit such an invasion in this parent-child relationship based on such old allegations, and including allegations that have, such as the 2025 allegation, that have an explanation as to my client's conduct. Remember, Your Honor, the resources and network that's currently surrounding and helping this family right now. Lots of help from family, therapists to DCFS. There's been a lot of actions that Mr. Mortensen has made that contradict what he's telling the court today. Most importantly, I think, his decision to give my client custody only 6 months ago, after 8 of the 11 incidents in his exhibits took place. As for the broader allegations in Dakota's protective order, the court will see on the 30th that this case cannot be reduced to a soundbite snippet of footage. We all know that social media has made its mind up about my client years ago, months ago, based on carefully curated information to paint her in a bad light. But the court...
I haven't followed it. I haven't seen it.
Yep.
Okay.
Good. But the court does not have that luxury. The court, unlike social media, actually has to get it right. The evidence, we believe, on the 30th, when viewed in its totality, will show who the real abuser is, who the real violent actor has been during the parties' relationship. The days and weeks that have transpired since entry of the temporary protective order have been an actual hell for my client for a variety of reasons. There's a couple of reasons. Sure, yeah, she's been castigated online, essentially re-victimizing her over and over again. Sure, she's had a massive opportunity ripped from her, but that completely pales in comparison to the fact that her parent time with her 2-year-old son has been outright suspended.
Well, you think you're giving me closing argument on the merits of the case. We're just talking about what's going to happen for the next
Sure.
3 weeks. Okay.
But that last point, though, I think is very critical. She's had no parent time whatsoever, and dressing up supervised parent time as something good for her or even good for the child, I don't think makes any sense at all. She's essentially being thrown scraps when it just does not make sense in the total backdrop of this case, Your Honor. Can I answer any questions for you?
I think I've asked them all.
Thank you.
I want to go to the guardian ad litem next, and we'll work our way back to the petitioner.
May I remain seated, Your Honor?
Please.
So
Do you have
before
the
I...
microphone near you?
Yeah, it's right in front of me. Before I get into my argument, I would just note, we did make a grammar request to Draper Police Department. We had a response on April 1st. That response was a denial based on the records being with the district attorney's office and the case basically still being open. So the district attorney's office, from what I understand, is screening charges against both parents.
Did you get any inclination? Counsel represented that he'd heard that they wouldn't be filing against either party.
Well, from what I heard, that was Draper telling him. I think it's the district attorney's office that makes the decision.
Okay.
And as of a week ago, it sounded like they were still making a decision.
All right, okay. We might know more on the 30th, right?
So I think, Your Honor, in looking at everything, the things that I want to focus on, and I know the 2023 incident is old, and frankly, it involved another child. But I think that it's important in assessing the potential danger to my child, to my client. I think the court touched on volatility, and that's what I see when I watch what's been submitted to the court. So going back to the 2023 incident, and I'll be brief with that. Charges came out of that. The district attorney's office filed a probable cause statement. This is directly from the probable cause statement. During the argument, respondent threw heavy metal chairs at petitioner, which put holes in the wall. After throwing 2 chairs, told petitioner to stop throwing the chair. Petitioner was told to stop throwing chairs because her child was next to him on the couch. Respondent then threw a metal chair which struck IP in the head.
That's, you're reading from the probable cause statement?
That was my summary of the probable cause statement.
Right.
But that's what the probable cause statement says. There were a litany of charges that were filed. There was a reckless child abuse charge that was filed. That was ultimately dismissed as a part of a plea agreement.
Okay.
The plea agreement was a plea in abeyance that would take it from a 3rd-degree felony aggravated assault to a Class A misdemeanor.
Sounds like she successfully completed those terms.
She has not successfully completed yet. So it was a 36-month plea in abeyance. They will come up on that 36-month period, I think in August, if I remember correctly. So she was required to do AP&P. She completed everything that AP&P wanted her to do quickly. So she's done a domestic violence evaluation. She's completed the treatment from the domestic violence evaluation. She's done a couple of parenting classes. And at least to date, she hasn't had new charges. She also was, I think, required to refrain from alcohol, things of that nature, typical AP&P things. She completed that fairly frequently. And in fact, I think the domestic violence assessment and the parenting classes were even completed before she ended up pleading on the case.
I think there was one I read, a low risk assessment. Is that?
Yeah, I think that they determined that she was low risk. So as I look at that, in my mind, she should have the skills to be able to avoid these situations. And then the May incident happened, May of last year. And what I see when I watch that video, and to be fair, I only have the video, and there's a starting point and there's an ending point, and who knows what happened before and who knows what happened after. But Dakota is holding the child, and that's clear in the video, and she's pushing him and telling him to get out of the house. And she's not just pushing him, she's shoving him, and she's shoving him with force. And at one point, it even appears in the video that he trips and almost falls over while he's holding the child. To me, that makes me very nervous about her ability to control herself and her volatility. I don't understand how you have a situation where you throw a chair at someone, knowing that your child's sitting on the couch, the child immediately starts crying, and this is going back to the 2023 incident, and you continue and continue and continue, and you don't immediately stop and attend to the child. That makes me very nervous. And then it's the same thing with this incident that happened in May. The pushing and shoving starts, the child starts crying immediately, and that doesn't snap her out of it. There are alternatives that could have been done if he wouldn't leave the house. Could have walked away and picked up a phone and called the police, asked for a trespassing charge. That didn't happen. That would have been the appropriate way to handle it. I think that the respondent in this case has a very difficult time with self-control, and I think that it puts my client at risk, and has historically put him at risk.
What about the argument made by Mr. Swinyard that but for the parties interacting with one another, that's where the anger is directed at him, not at the child, even though it may be inappropriate conduct, that if they're not in the same place at the same time, that the triggering elements are not there for her to lash out.
I agree that the anger is directed at him. I don't think that the anger has been directed at the child. That's actually demonstrated, I think, in the child abuse charge that was originally filed. They filed it as a reckless charge, not an intentional charge. So I think the anger is directed at him, but I'm not convinced that there won't be anger directed at other people that can result in the children being harmed. That's my concern, is just a lack of total self-control, even having been through all of the treatment for domestic violence and things of that nature. And that really concerns me. So I am asking for supervised visits today. I think the court can order that if the court finds that there's potential harm to the child. I think based on what's happened historically, the court can find that. We've discussed doing third-party supervision. That was one of the first requests I made when people reached out a couple of weeks ago, is send me people who I could consider for third parties. I hadn't made a decision at that point or even looked at the evidence, but if it got to that, I wanted to be able to vet people. I heard back from Petitioner, who was suggesting an agency. I heard back from Respondent last night with one person, and then they provided 3 more this morning, so I haven't looked at them. As the court knows, the statute prefers an agency for reasons about neutrality and, being trained in child abuse reporting and things of that nature. I think that it would be appropriate to do an agency.
How old is the child in this case?
He's
again?
2.
2, so you couldn't really interview this child.
Correct.
All right. Anything further?
No.
All right. Let's go back to you, Mr. Swinyard. Any rebuttal on what the guardian ad litem has just indicated?
No, I would just emphasize what I've already said, that her anger is very clearly, unambiguously directed at Dakota, has nothing to do with the children. So at this point, we do think it is appropriate and certainly consistent with what these folks have historically practiced to suspend and essentially strike those paragraphs 15 through 17 from the temporary protective order and restore that custody arrangement that he agreed to along with my client only 6 months ago.
Okay. All right. And let's go back to you, Ms. Diaz, for rebuttal.
Yes, Your Honor. So the first thing I'll say is that, a mutual protective order can't be entered under the rule. And in this case, it wasn't filed when it could have been filed previously to have that argued today. So that isn't what is being argued today. And what we are looking at today are parent time orders moving forward. And I think that a request for supervised parent time is not prejudicial under the statute. In fact, it's something we see often in cases of domestic violence. And some of what was brought up by opposing counsel here, I think, can really be understood in the larger context of what a cycle of abuse looks like. What 2 people who are maybe sometimes cohabitating, sometimes not, going through a cycle of making up, fighting, breaking up, going through a honeymoon phase, having this incident, having an incident happen, and the entire thing start all over again is what we see here.
I know the cycles of domestic violence.
Time and time again, what we see is that the respondent is the aggressor here, and that she not only is putting my client at risk, but the child at risk as well. And let's just turn to a couple of things that were brought up. So looking at the February incident, my client was invited that day. In fact, one of the ways that we'll see as this, plays out coercive control happening is that he's often invited back, and his child is often used as a pawn to start fights, as a pawn to create incidents. My client is doing everything he can at this point to try and protect his son. That's what this case is about. That's why we're here today. So the orders that are made here today for the minor child are extremely important. They're extremely important because this is the case. This is the case for the petitioner, is being able to keep his son safe. Leaving in abusive circumstance is not easy. It's not easy to get away from. Many people attempt many times and fail many times. But what he's doing here today is trying to protect his son. And her violence and her behavior, it has escalated since the initial 2023 incident. Now, they did reach a stipulation in their custody case, and
That was after the May incident.
and that was after the May incident, and that's really common, I think, in cases where people are trying to make up, trying to play nice with each other, have been getting coerced by the other party for some amount of time, but also...
Well, it's a different context. I mean, they were in a formal mediation setting with attorneys, all right? It's a little bit different than making promises, I think, after an explosive event, but okay.
Since then, there have been more incidents, Your Honor, and there has been the February incident. And if we want to look at how the parties behaved after the fact, go ahead and look at the petitioner's Exhibit 10, which shows that after the February 23rd and 24th incident, the respondent made 151 phone call attempts to him.
I'd object as to foundation. The date of those calls has not been demonstrated, cannot be demonstrated from Exhibit 10.
I mean, I think there's a point there as to what the relevance is about that.
Well, Your Honor, this would be for the purposes of rebuttal. What opposing counsel said was that after that incident happened, that his client was trying to get away from my client and not be around them, and that isn't true based on their call logs.
I mean, I think it might be relevant in the context of whether a protective order eventually issues, but I'm not finding that it's relevant for purposes of parent time for the
Your
next
Honor,
3 weeks.
I guess what I'll say is there's some credibility problems happening here on the part of the respondent as well, and what's being reported by the respondent as well.
There may very well be. Certainly, it's not the first time that we've heard disparate factual representations in the context of domestic violence.
Of course. So, and as far as I know, there was a discussion about police reports. As far as I'm aware, Your Honor, I don't know that those are going to be released until the police department determines that their investigation is finished and that file has been closed. So we'll see what happens moving forward with that. But there are more incidents that show that more recently violence has been directed towards the minor. I'll draw your attention to Exhibit 9, in which the parties were in an argument, and it's mostly an audio, but the respondent kicks down the minor child's door. Well, when the minor child was in there, kicked the door down when the minor child was in there sleeping. And so I think that supervision is incredibly appropriate in this case. Although there are voluntary cases with DCFS open, those cases are voluntary. There isn't any judge that can enforce that if either of the parties decide to stop complying with those services or decide that they don't want to move
You're talking about
forward.
voluntary services. We're not talking about, or are we, about an open investigation into allegations of child abuse.
So, Your Honor, the division has not supported child abuse. They've supported domestic violence-related child abuse against the respondent, and they've supported failure to protect against the petitioner.
Okay.
And they're working they call it a voluntary case. It's essentially giving them services.
Okay.
So essentially, a case would have to be filed for those services to be able to be court enforced. And I will say that since that stipulation on the custody case was reached, The parties were following it somewhat, but the respondent was out of town for a lot of that. She left to go to work. She was out of town for like several months. So my client has been a primary caretaker for this child. He is completely capable and able of providing this child with the care they need.
Again, we're just talking about her parent time between now
Yeah.
and the 30th of April. Okay.
So we're in support. We will agree with everything that the guardian ad litem has argued, Your Honor.
All right, I'll go ahead and make my recommendations. I'll close argument at this time. And I just want to reemphasize that, once again, the decision that I'm making today is very limited in duration. We're talking about a parent time arrangement that'll be in effect for a little over 3 weeks. Well, yeah, a little over 3 weeks, all right? And then we're going to have a full hearing on the merits of what may be competing petitions for a protective order. There may be a parent time order that comes out of that as well. So we may be doing some of this over again. And we may know more information by then too. We might have a police report at that point. We might know whether or not, for certain, whether there's going to be criminal charges filed against one or both of the parties. And so, and I want to emphasize too that I'm not making any determination today, one way or the other, about whether the respondent in this case may also be a victim of an abusive partner as well. I mean, that's part of the allegations that are being made. There's mutual allegations at this point. The prior allegations have played themselves out in the criminal court. I don't know at this juncture, hearing what the guardian ad litem indicated about there's not yet been a dismissal of that prior criminal matter. I don't know what may come of that. It may be dependent upon what law enforcement intends to do with the current incident, the February incident. I do give a lot of weight to the input of the guardian ad litem as well. Guardian ad litem is someone who's trained, well, someone who's trained in forensic interviews of children, but the child is really too young in this case to provide any valuable information. But the guardian ad litem also, his only interest is in advocating for the best interest of the child, not getting necessarily a spin from what would be an inherently biased party, meaning mother or father. Not to say that they're not each from their own perspectives being truthful, but simply that there is an inherent bias there as well. And I do share some of I have concerns going both ways, quite frankly. I do have some concerns on the one hand that perhaps there has been some, as I indicated, maybe pushing of buttons to get a reaction. It's certainly been, no one disputes, a volatile relationship. As I looked at some of the evidence that was submitted, it seemed like a lot of this was going on when he was coming to her place of residence. That could have an impact. But also, regardless, the reactions that, even if he was trying to provoke a response, the reactions that actually occurred, they're very troubling. I mean, the one from 2023, I'm not giving as much weight to because it's removed in time, but it's still indicative of volatile reactions. And the hard part for the court is when it happens in the presence. I mean, it's hard in any event, but especially when there's children present during the incident. That's the most difficult part of all. The May 2025 incident it occurred while the child was in the arms of the petitioner. And there just doesn't seem to have been any thought put into what the effect that this might have upon the child. And that weighs heavily with the court. And so for these reasons, I'm going to recommend, again, this is very limited duration, we'll have more information, but I'm going to recommend supervised parent time for the next 3 weeks and 2 days until we come back on the 30th. And we'll have more discussion about this. And I would allow that to be for up to 6 hours per week. We can break it up into 2 3-hour periods, 3 2-hour periods, whatever frequency works for her at the availability of a supervisor. The statute does talk about now, it's sort of flipped on its head, the old order of preference would be to relatives, friends that might be available, moving more towards a paid supervision service. As of May of 2025, with Ohm's law, that's changed. And now the preference is to a professional individual. Well, let's start. It would be a professional individual or private agency trained in child abuse reporting laws, the developmental needs of a child, and the dynamics of domestic violence, child abuse, and sexual abuse and substance abuse. If that's not available or practicable under the circumstances, then we can turn to an individual that has these similar types of training. And then if that's not available or practicable, then we're looking at friends, family, relatives, that sort of thing. I don't know if there was an agreement between the parties as to a mutually agreed upon third person that could do this or not.
There's not an agreement.
Historically, there's been an agreement. Historically, they've participated with 4 different friends and family members in providing care and supervision of the children.
Was there a proposal that was set forth by you or your client to the guardian ad litem as to who ought to be?
Yes, we're proposing that the parties be able to use those 4 individuals as part of the, if there is to be supervised parent time, that the court uses those 4.
Are these people that are aligned with her?
Well, it's safe to deduce that. One is our client's mom, client's sister, a cousin of my client, and then a shared nanny that both parties have used. But again, even though on paper they appear to be aligned, Dakota has actively taken advantage of these services, or taken advantage of their time historically.
I think in some respects too, and I don't know if you've considered that using a supervision service might actually protect her from false allegations as well. I think the concern that comes up with friends and family is that on the one hand, let's say if there's someone that's selected by the one to be supervised, the other parent may feel like they just won't do their job. On the other hand, if it's someone selected by him, she may feel they're hostile towards her and it won't be conducive to effective parent time. So at least you're having a neutral observer who's
Sure.
documented that might give us some indication about how's the child responding when she sees mom after a while for a long time.
Sure.
It might actually be beneficial for everybody.
My client's very interested if she's being given a very small amount of parent time, which the court has said 6 hours. Mr. McDonald has separately told us he'd be looking at more like 8 hours. So I think that would be worth a separate discussion.
I'm okay with expanding that, yeah.
She's very concerned about the quality of parent time and believes that the quality of parent time will be better with someone who the child is familiar with, someone who my client is comfortable with. And, you know, the court has already indicated some reluctance or some openness. I believe that this certainly would at best be an edge case for supervision. So if there is a case that the court can drift away from the statutory preference and allow family to step in, I think this would be it.
Have you vetted anyone?
So, Your Honor, I have not fully vetted everyone. So they gave me the 4 names. The first 2 names, the one thing that I did, because I just had time to do it because I received the names this morning, is I called the DCFS caseworker and asked her for her opinion. She was unfamiliar with the second 2 names. The first 2 names she was familiar with. Her concern would be that she believes that that client is very aligned against Petitioner. And that would be my concern too. But what I would be willing to do is vet these folks for when we come back on the 30th and maybe have a different recommendation.
Do you have instructions for proposed supervisors as to what their obligations would be?
Our office has instructions that we would discuss and confirm that they would be willing to do it.
I might be willing to go there vetted by the guardian ad litem, and we get a statement from the proposed supervisor that they'd be willing to submit themselves to the jurisdiction of the court so they can be held accountable.
Zero problem with that. That's something we can work on today with those folks.
Okay, I'll increase it to 8 hours. Certainly, it's going to be subject to availability. I'm not eliminating necessarily paid supervision. I don't think this is necessarily an intentional child abuse case either. I do think that there's potentially incidental child abuse that has occurred, domestic violence in the presence of a child. So I still have some concerns, but certainly if they're being vetted and approved by the guardian, if they're submitting themselves to the jurisdiction of the court, it's going to take some interaction between counsel to try to work out a schedule between now and when we get back, okay?
Great. Yeah, we can work on that immediately, Your Honor.
We're talking a 2-year-old, maybe frequent, shorter sessions may be better than one long session
Sure.
or two. Yeah, all right.
So as I understand it, the court, pending the guardian ad litem's vetting of the options, the court would allow supervision to take
will.
place by these folks in addition to having the option of a professional supervisor.
Right, and I'll just indicate too, pursuant to statute, that this is only designed to be in effect for as long as necessary, and if it goes beyond the next hearing, we'll probably have periodic reviews as well. All right, as required by statute.
And Your Honor, I know that my
I don't know that it
client
will.
has some concerns about some of the respondent's family members
Mm-hmm.
being able to hold boundaries and keep her to account. So would it be a requirement that that document, submitting them to the jurisdiction of the court, would that have to be filed before those things could take place?
I want that to happen, yes.
Okay.
Yeah,
No problem.
okay. All right, anything else from either party, guardian ad litem?
That I'm aware of.
Okay, we'll issue then an amended temporary protective order with the ruling as indicated today. We're working on that now. It may take a few minutes to get that drafted, and I'm going to want to review that before it's issued. If you
Do you
want,
want
we can
to-
print off a draft and have the parties look it over, and then if there's an issue, I can come back, and otherwise, as long as everybody approves of it, the attorneys and the guardian ad litem, we can go ahead and get that issued. And if need be, I can come back if there's a need for clarification.
Your Honor, do you have any scheduling concerns now with the latest, with my client's request for protective order having been filed? Do you have any scheduling concerns for the 30th? We're set to go at 3:30 on the 30th.
It's the same incident, right?
Same incident, I guess, just more stuff.
There's a lot of overlap that I'll be hearing. In other words, I don't think it's going to take much, if any, more time than if I'm hearing only one
Okay.
protective order action versus another.
All right.
My main concern is being able to have my staff go home at 5. But if it needs more time, we'll if you think it's going to need more time than an hour and a half, let me know, and we can perhaps do a scheduling conference to tweak the time, and so we can give you as much time as this case needs and deserves.
Thank you. We'll reach out to your clerk then, once council's had a chance to look at the documents and
Okay.
evaluate it.
Okay, all right. Note, I'll be gone between the 16th and the 23rd.
All right.
All right, court will be in recess until 1:30. Let me know if I need to come back, okay?
Mayor, remain seated, court is now in recess.
I think I forwarded
it to you this morning.
I
think I did.
Maybe,
I don't know
maybe
for
I
sure.
was driving, because I just want to review the
I've
minutes.
forwarded it probably at 10 o'clock.
We'll get phone numbers.
Yeah.
Okay.
Could you
Give us
just
a
send me
minute.
the name, the list of names?
List names, yep,
Yep.
we'll definitely do that now.
Thank you.